is summon basically? For example, summon is a written document compelling the attendance of witness to attend the court on particular day, particular time under penalty. So there will be signature of the judge, there will be seal of the court also. So summonses is singular, summonses is plural. Summons also known as subpoena. Sub means under. The pena means penalty. So it comes under 63 to 71 BNSS. So this can be MCQ. Summons comes under 63 to 71 BNSS. Bharatiya Nagarika Suraksha Samhita. So what is the definition of that? It's a written or typed document by the court. So it's by the court compelling the attendance of witness. You need to attend the court on a particular day and time. Okay? To depose evidence. For what purpose? To depose evidence as a common witness or expert witness at a particular date and particular time for the purpose under penalty. So it is a punishable offence. So if you are not attending court, disobedience of the summons issued by the court or public authority can be punishable offence. They can arrest you, they can issue warrant. The warrant can be bailable warrant or non-bailable warrant. Okay, if you have some emergency, you need to inform the court, so and so me, doctor having this emergency, I am unable to attend the court on particular date and time, so can you just give me some other date like that. So you can inform the court. So disobedience of the summons is a punishable offence. Types, there are basically two types, subpoena and testificandum. So that means to give oral evidence, to testify oral evidence. So testificandum basically oral evidence. Then ducis tecum, so to depose documentary evidence. To depose documents. So these are two types. Okay? How to remember? Testificandum. Testify, that is basically eyewitness, common witness, expert witness. That is the oral evidence. So oral evidence can be cross-examined. That's why it has more value than documentary evidence. Then the question comes, witness fails to attend court without any valid reason. So that is 208 BNS. So they can issue warrant. So warrant can be bailable warrant or non-bailable warrant. This can be asked in your exam. Who will serve the summon? So basically the summon is served by a police person, usually by police constable. Nowadays, in some states they introduced digital summon. They send you the summons through the email or WhatsApp also. In some states, not in all the states, to electronic media. What if a witness receive two summonses on the same date? Two summonses, 1, 2, on the same date. It happens actually. So one from the civil court, one from the criminal court, or one from the high court, one from the session court, or one from the magistrate court, one from other magistrate court. Which one you are going to attend? So this is very interesting question. So you can attend only one court. Yes, sir. So remember, it is simple concept is attend higher court, higher court. So attend higher court than the lower court, irrespective of the type of court, civil court or criminal court. Irrespective of that, you attend higher court. So right here, higher court. Then criminal court, they have preference over civil court. Criminal court. Then comes is, if it is of same type, say same magistrate court and magistrate court, then you can attend the court, so from which you receive the summons first. First come first. Summons first. Okay. So this is very important concept. Conduct money. What is conduct money? See, as an expert, as a forensic expert, we do, attend summons in various courts, including Delhi High Court, Delhi Tis Hazari Court, like that. See, once we attend, we get TAD. In criminal cases, we get TAD, traveling allowances and daily allowances. So basically, it is the expenses that is to be paid by the court. So conduct money is the money that is paid in civil case. So TA is different, conduct money is different. Conduct money is money paid to the witness to attend the civil case, not in the criminal case. So try to understand this. So conduct money given in only in civil cases. So now here is the question, and before that, we have some IPC sections also, like perjury. So definition of perjury, that is 227. Punishment for perjury, that is 229 BNS. So let's have a discussion of this. Ravi receives a summons is singular, from local police station. So local police station are from public authority or from the, that is basically high court or court. So to appear witness in a particular case, summons clearly states that he must be present at the police station at 10 a.m. on specific date. Ravi, despite being legally bound to attend, he decided not to go to court, not to go to police station on the given date and time. So that means he is intentionally omitting to attend. Okay? So it is punishable with 1 month of imprisonment. So what is this known as? So this is known as 208. So 208 BNS. So if it is a police station, it's 1 month. If it is a court, then it is 6 months of imprisonment plus 5k rupees fine as per new BNS 208. 64 is punishment for rape. 66 rape and murder, a persistent vegetative state. 229 is punishment for perjury. Then forms of summons, so it can be in writing, I said already, or it can be nowadays summons in the form of electronic communication as well. So Madhya Pradesh leads the way. So it is the first state to introduce online summons system. Online summons system, that is known as digital summons, Madhya Pradesh. Okay, so this you can memorize. Then already I discussed, when doctor receives 2 summonses on a particular date and time, you need to attend higher court. You need to attend criminal court. Then first come first. So this is what the very important concept asked in the exam. Now, look at this question asked in your NEET PG. You have received 2 summonses to be attended on the same date. Which court summons would you give preference? Option A, one you receive first, given preference, irrespective of type of court and the case. No, it is wrong. Irrespective of court, no, that is wrong. Criminal cases will be given preference over civil cases, irrespective of type of court. No. The first rule is higher court. IPCs under which case is filed will be used to decide to preference. No, it is also wrong. So the best answer is higher court will be given preference over the lower court irrespective of date of receiving of summons and the type of case. So this is correct. So the answer is C is the best answer. C. C is the accurate answer. Yeah. Next comes is the witness. See, I remember asked in the exam, a doctor is, say example doctor is, common witness or expert witness. What do you think? See, a doctor can be a common witness. He can be expert witness. So most of the time expert witness, he can be both. That is the best answer for the question. What do you mean by witness? So witness means a person, remember it's a person, not a document, a person who provides evidence about the fact in the court of law under oath. So it's a person basically, comes under 124 to 139. There are different types of witness: common witness, expert witness, hostile witness, dumb witness, like that. So commonly it is common witness. So common witness means can be any person, literate, illiterate, dumb person, any person can be a common witness. So he is a witness. So based on the things perceived by him or things seen by him. Like example, eyewitness in case of murder, attempt to murder, eyewitness in case of domestic violence, eyewitness in case of dowry death. So common witness. He's a common man basically. Then expert witness, like example, forensic medicine expert, MD in forensic medicine. So can be expert witness. We have more responsibility than the common witness. Okay, we can give opinion, we can volunteer our statements. Okay, yes. Then hostile witness. So and it is again asked in the exam. Hostile witness. In simple word, hostile witness means U-turn witness. U-turn. That means U-turn. We say no U-turn like this. U-turn means the person giving different statements or contradictory statement. Like in police investigation, he gives some statements. And in the court, he gives something opposite to the statement given by him during police investigation. So we call it as hostile witness. So hostile witness is a person, one who gives contradictory statement and different statements during police investigation and the courtroom proceedings. Yeah. So dumb witness, is it valid in court of law? Dumb witness. Yes, dumb witness also valid in court of law. He can give his evidence either by writing. The court can allow the writing. Then by gesture also. Sign language. So this is about the dumb witness. So look at this now, one more very commonly asked. What is the difference between common witness and expert witness? See here, consider a case of murder. This girl is the witness, common witness. Why common witness? Because she is going to give the witness or the evidence about the things which observed or perceived by her. So this is common witness. And you can see her forensic medicine expert. We are examining skeleton and we are going to give the opinion. Expert witness. So okay. So like example see, forensic medicine expert. Basically they are expert witness. Okay. So yes. Now differences. Legally defined under. Again fact-based question. 124. So common witness defined under 124. So try to memorize one part of the table, then you can memorize other part of the table. Who is common witness? Any person who has actually observed or perceived some facts. First-hand knowledge, we call it as first-hand knowledge. Things which are seen, things which are heard, first-hand knowledge. Person can be any person, can be layman, literate, illiterate, any person can be common witness. Ability to draw conclusion, opinion from the observation. Can he conclude? No, he cannot. He don't have any power to conclude as a common witness. Can he volunteering the statement? Can he tell something new about the case? No, that is not allowed. He cannot. Responsibility? Less responsibility. But when you see the expert witness here, comes under 39 BSc, a person who is skilled in a particular field. Like example, DNA, typing expert, fingerprint expert, or doctor. Okay? So, he can give the opinion, he can draw the conclusion. He can also volunteer the statement. Then, high responsibility. So, they have high responsibility. They should be very careful while giving witness in court of law about any case. So, this is asked in exam. So, what are the question asked? One is 124, 39, then these two. The 4 and 5 points, very commonly asked in the exam, you need to memorize. Then hostile witness, already I said, it is what written in 157 BSc. I said already, hostile witness is a witness whose statement in the court is contradictory to the statement made in previous deposition, statement recorded by the police. So, in police investigation, he tells some other story. And in courtroom proceeding, he tells some other story. So, both the story, they're opposite to each other. So, he is taking U-turn. So, probably, probable cause may be bribery, fear, threat, love affair, jealousy, long trial, all this. Okay, anxiety can be. So, this is what hostile witness. Hostile witness gives statement against the party who called him as a witness. So, this happens commonly during courtroom proceeding in some cases. Hostile. What about leading questions? Now, very interesting question. See, leading questions means yes or no type of questions. Leading questions are not allowed in examination in chief. But if public prosecutor, if he confirms that the witness is hostile witness, then he can ask leading questions, that is yes or no type of questions. So, this is asked in the exam. Leading questions are allowed in examination of hostile witness and examination chief. Then, what are the reasons I said? Threat, fear, love affair, maybe, bribery, vitamin M, jealousy, delayed, prolonged trials. So, all these are the causes hostile witness. Now, question comes is, what is the difference between hostile witness and perjury? See, perjury is the act committed by the hostile witness. Hostile witness is a person. So, perjury is a broad term. It includes hostile witness as well as other types of perjury. Yeah. Now comes this very important topic. What are the duties of doctor and witness box? As I said, so we are all experts. We are going to give death certificate, wound certificate, postmortem certificate. We can also record dying declaration. So, all these documents should be cross-examined by the court during cross-examination. So, some or other day, we are going to be summoned by the court. So, what are the duties? Like example, I said, postmortem certificate. What are duties? So, duties are divided into like this. Before reaching the court, after reaching the court, within the witness box, after the evidence. So what are the duties briefly? So now here question comes is apron, wearing apron, is it compulsory to give evidence? What do you think? No, it is not compulsory, but decent dress is sufficient enough. So before reaching court, keep copy of all the summons. So keep the summons because there will be hundreds of cases in the court and different types of courts in a court hall. So you need to have a summons. Then well prepared with the concerned documents. So whatever document required, well prepared. You are a man of science. So you are a man of science, you are expert. Doctor, you are expert, you are a man of science. Be very confident. Face the court proceeding with lot of confidence. Apply for leave permission from head of the department. When you are working in some department in a medical college, apply for leave and also permission from head of the department. Well dressed, modest. Well dressed, I said well dressed. Dress sense important. Modest, be modest. Then, duties and conduct of a doctor after reaching court. So once you reach court, you just go to public prosecutor. So public prosecutor means government advocate, government lawyer. You just go to him and introduce yourself. Me, so and so doctor, coming from this hospital, this medical college, to give evidence in this particular case. So show him summons. Go through the case records. You can get some case records from the public prosecutor. You can just go through that. Clarify your doubts with the PP. If you have any doubts, you can clarify with the public prosecutor. He will definitely help you. Frame some questions likely to be asked by the judge. Yourself think what are the questions can be asked by the judge. So most of the time, opposite lawyer or defense lawyer can ask you anything. You should be ready with these type of questions. Then, in witness box, what is your duty? Be relaxed, calm, polite, honest, truthful. Don't be nervous. Don't lose temper. Relaxed. Around, say, just like this. Okay. Calm and polite. Sir. Yes, sir. No, sir. Honest. Truthful. Don't be nervous. You are man of science. You are doctor. Don't lose temper. They can ask 100 of things during cross-examination. Don't lose your temper. Okay? Yeah. Then, address judge by sir or madam or your honor. Sir, madam or your honor. Like that. Okay? Then, never underestimate the medical knowledge of advocates. Advocates, they have very good legal knowledge. And some advocates, they also have very good medical knowledge. Never underestimate them. Be prepared. Listen to questions carefully. Listen to all the questions carefully. And think before answering. So, should have patience. Should wait. Should listen to the questions. Then you can answer carefully. Answer only what is asked. Give direct answer. Give direct answer. Take example, what was the weapon used? Knife was used. What was the size? Yes, you can tell. What was the cause of death? Yes. What is the reference? You can tell the reference is from this book, this page number, this edition. Like that. So give direct answer. Use simple language. Use simple language. Like instead of using anterior and posterior, you can use front and back. Instead of using medial and lateral, inner side, outer side. Like that. Okay? Avoid technical terms because you are doctor, you are well aware of all the terms. But advocates and judges, they don't have a lot of medical background, especially technical terms. Avoid technical terms. Do not avoid any question. Do not avoid any question. Then you can give your opinion. Avoid the statement like this. I imagine cause of death is. I almost cause of death is. Don't do that. You just give a proper statement with 100% confidence. Mostly, maybe, may not be. No. This type of statement you should avoid. Then, I think, no, it is 100% correct statement. Okay, so like that it is. After deposing evidence, so once you depose evidence, then you should not leave the court without the permission from the judge. So always greet the judge before leaving the court. Take attendance certificate. You may ask for your PP for traveling expenses. So in some cases, I have visited from Bangalore to Delhi. So after the all courtroom proceedings, after deposing evidence, they usually reimburse traveling expenses. Okay, that you can collect. So this is how actually the courtroom proceedings and duties of doctor that takes place. Okay. Yes. Now comes is how actually the courtroom procedure that starts and ends. Okay. Now for that I have a good picture here. Okay. We have